other courts are closed down and that other litigants are not allowed to have their day in the market. I'm fair-minded enough to know that a system that does not allow other litigants to have their day in the court just because of one litigant cannot be said to be fair. I'm a human rights activist and constitutional lawyer. I know that my conscience, also as a Christian, does not agree with that. But there are areas in the new practice directions that I correct with. In other words, I do not mind if they move the venue to another place that does not disturb other litigants and clients and witnesses and all that. But I'm worried about one provision that screens off journalists, the media, the fourth estate of the realm under section 22 of the Constitution. Because if you stifle information, the wrong information can emanate from the rumor mill, and that is a more dangerous issue. The Supreme Court said so, and I think that was in the case of Adesanya versus President of the Senate. If you stifle information, then the rumor mill will become very active and things will begin to germinate. We have a proverb in my home, in my language. I'm from Iyukwe, near Agenebode, East local government area of Edo State. The proverb is, Ono ayoelaza vuyuko, lo kazo mo agule. What does it mean? He who was not present when a fat he-goat was butchered will argue later that a fetus must have been removed from his tummy after it had a big tummy. In other words, seeing is believing. You don't hide information. So when you prevent the media from covering a trial, then it may lead to generation within the rumor mill of things that never happened, which again jeopardizes the fair trial of an accused person, even of the prosecutor and even of the judiciary itself. In terms of witnesses attending, I have no problem with witnesses being screened off. That is good to safeguard the interests of the witnesses and the fact that you refer to them as A or B instead of by their names. That safeguards them. That is a very wise decision. Safeguard witnesses, screen them off. Or if you want to use Zoom, fine. Although that is subject to whether when you use Zoom, whether cross-examination can also be allowed in that method, or whether the court can be said to watch the demeanor of the witness. But I am not therefore much against the issue of shifting the venue to a more convenient place. That is fair enough. I'm not against the issue of screening of witnesses. That is fair enough. But I'm against the issue of making it look like a secret trial, as if a trial is like a gathering of witches and wizards in a coven. It should be a public trial which the whole world can watch. Then when you come here, you can screen out the people and decide on how many people can attend, the same way we have been doing it. I believe that because of that, by the grace of God, I'm going to challenge some portions of the new practice directions as being unconstitutional and against so many sections of the Constitution of Nigeria, which is the ground norm of the Nigerian law, which are referred to at different fora as the Oba, the Eze, and the Emir of Nigerian laws in the hierarchy of laws, the ground norm, the Fronts Aid Origo, who will challenge those sections.
We'll all recall that on the last adjourned date, we moved an application seeking for the discharge of the defendants on all the counts, the 15 counts filed against the defendants. And the court, in its wisdom, now reviewed all the charges and discovered that with the exception of 7 counts, about 8 counts appear to be similar, and those charges were struck out. Now, it would be also understood that in the argument of the defendant, the account that is reflected in the charges, when you go to the charge, you get to know all the counts. But all the counts relating to terrorism are really sustained by the court. And they make heavy weather on the issue of rendition, and the court bluntly said that rendition in this situation is allowed, because rendition in criminal law, in criminal case, is allowed. After all, the defendant is under a bench warrant, and anywhere he is seen, the law allows him to be taken and be forcefully brought to court. And that was what exactly happened. And again, with respect to membership of IPOB, which he denied, it was the argument of the defendant that the matter is on appeal on whether IPOB is a proscribed organization under the Nigerian law or not. The court also emphatically said, even though the issue is on appeal, but what is in place is that IPOB still remains a terrorist organization within the confines of Nigerian law. And immediately thereafter, they moved another application for bail again, which the court ordered that such application be taken, and arguments were proffered. And it was also in their argument that Nnamid Kanu had never flouted any of the conditions of the bail. And we have argued vehemently, showing to the world, showing to the court that he has actually flouted all the bail conditions. And that was the reason why the court has ordered for his, revoked his bail and ordered for his arrest. And it was also our argument that what we should be talking about is contempt of court, not even issue of bail anymore. And we are awaiting the response of the court on the next adjourned date, which the case is never adjourned till the 17th, 18th, and the 26th of May 2022 for ruling and continuation of hearing. But one thing that is very significant that I thought I should mention here is that the court has already hinted us that arising from the new practice direction, considering the inconvenience this case has always caused other courts within the premises and other offices within the premises, moving forward, this case will be heard in other places that will be communicated to parties before the next adjourned date. This, I thought, is very important, and I thought I should let you know.
Sir, journalists were today, accredited journalists were barred from gaining access into the courtroom. What's the position of the prosecution?
Well,
we just afforded you the platform to tell Nigerians what transpired in the courtroom, and we were not allowed to go into the courtroom.
Well, I think with respect to that, that will be the business of the information unit of the Federal High Court. I am to give you what actually transpired in the court. So I'm afraid I'm not able to. I will not be able to respond to that. Well, the issue of jurisdiction, already the court has already sustained that. I mean, refused that issue of jurisdiction. This court has the jurisdiction to entertain this matter, and that is the more reason why this matter will continue with the remaining 7 counts against the defendants.